Hey everybody, we're back in the shanty. So today we're going to talk about the National Labor Relations Board. Before you shut this off, because whenever I talk about the NLRB, half of you shut it off. We're going to talk about the NLRB, the National Labor Relations Board, in the context of employee handbook rules and work rules. So don't shut it off. You're going to want to hear this, especially if you're thinking about reviewing your handbook or renewing your handbook or doing something with your handbook anytime in the very near future. So as we start, we got to go back to August of last year, August 2023. The board issued what it called its Stericycle. I don't know if I'm pronouncing that right or not, but it's Stericycle, Stericycle Inc. decision, in which the board adopted what it called, quote, a new legal standard for evaluating employer work rules challenged as facially unlawful under Section 8A1 of the National Labor Relations Act. And what the board did in that decision was what they do a lot and what they've been doing a lot lately. They overturned a couple of old decisions, one Boeing and Company from 2017 and another one called LA Specialty Produce Co. from 2019 that had set the standard. And they go back to what they call the previous standard from Lutheran Heritage Village and blah, blah, blah. Here's what the board said in their press release. In Stericycle, the board explained that the primary problem with the Boeing and LA Specialty Produce standard was that it permitted employers to adopt overly broad work rules that chill employees' exercise of their rights under Section 7 of the Act. Under that standard, an employer was not required to narrowly tailor its rules to promote its legitimate and substantial business interests without unnecessarily burdening employee rights. The board also rejected Boeing's categorical approach to work rules, under which certain types of rules were held to be always lawful, regardless of how they were drafted or what interests a particular employer cited in defense of the rule. In other words, the board is saying we're rejecting a standard whereby you get to know what the rules can be ahead of time so you can draft them appropriately. It's a little editorial there. The board went on to say the following. Under the new standard adopted in Stericycle, the General Counsel must prove that a challenged rule has a reasonable tendency to chill employees from exercising their rights. If the General Counsel does so, then the rule is presumptively unlawful. However, the employer may rebut the presumption by proving that the rule advances a legitimate and substantial business interest and that the employer is unable to advance that interest with a more narrowly tailored rule. If the employer proves its defense, then the work rule will be found lawful to maintain. In line with this framework, the board rejected the categorical approach of Boeing in favor of a case-specific consideration of work rules. Again, a little editorial. In other words, the board rejected a standard by which you can know ahead of time what your rules should be so that you don't draft them inappropriately, and instead put in place a case-by-case analysis where you're only really going to know if the rule is valid if it gets litigated and if it's upheld by the board. It can be expensive for you. So why are we talking about this? This was in August of 2023. Well, we're talking about it because in February, it is February, a couple of weeks ago, an administrative law judge issued a decision following this new standard. They did it right here locally. About a local company, a great big auto producer, and a local union, a auto union, and it involved 10 work rules, all right, that were questioned. Now, what's interesting about this case is that these work rules weren't in an employee handbook in a non-union shop. These work rules were actually part of a collectively bargained for collective bargaining agreement. It was a 2019 local agreement that contained local shop rules that was negotiated between the company and the local. That makes this a little more disturbing than if it was just somebody's handbook. It's disturbing nonetheless. And some of these rules had been in place since 2015 in one form or another, according to this case. And I suspect even longer than that. Here's what the shop rules said that we're going to talk about. Committing any of the following violations will be sufficient grounds for disciplinary action, depending on the seriousness of the offense in the judgment of management. 1, falsification of personnel or other records. 10, distracting attention from others. 18, wasting time or loitering on company property during working hours. 20, threatening, intimidating, coercing, or interfering with employees or supervision at any time. 21, unauthorized soliciting or collecting contributions for any purpose whatsoever during working hours. 24, misuse or removal from the premises without proper authorization of employee lists, blueprints, company records, or confidential information of any nature. 28, the making or publishing of malicious statements concerning any employee, the company, or its products. And 29, abusive language to any employee or supervision. Here's what the judge held, the ALJ held. I find that SHOP Rules 10, 18, 21, 24, and 28, as alleged in paragraph 7 of the complaint, have been unlawful to maintain since January 13th of 2022. The remaining SHOP rules alleged in paragraph 7 are lawful to maintain. Now, first of all, we're talking about January 13, 2022, because there is a limited statute of limitations in section 10 something of the NLRB that where you can only go back 6 months. And based on when the complaint was filed, January 13, 2022 was 6 months before the complaint was filed. So that's how far we can go back, even though the rules have been in place much, much longer than that. So let's talk about a couple of these rules. And I want to use them as an illustration of how incredibly difficult it's going to be to craft rules and how really precise you're going to have to be in your language when you're doing this, okay? It's going to cause me to read a little, so when I look away, I'm not ignoring you. I'm going to start with SHOP Rule 20, if I can find it. SHOP Rule 20 prohibited, quote, threatening, intimidating, coercing, or interfering with employees or supervision at any time. And the judge actually said this was not an overly broad rule. It's a perfectly acceptable rule, according to the judge. Now, the general counsel argued that the rule was overly broad because its language was ambiguous. The GC said its operative component parts, threatening, intimidating, coercing, or interfering, were not sufficiently defined and could reasonably be construed by individuals to include such protected concerted activities as heated debates over the benefits of having a union and the terms and conditions of employment. The respondent, the company, on the other hand, just argued, look, this is a civility rule. It's a simple civility rule. The judge actually found that this rule was not overly broad. And here's what he said. I find that SHOP Rule 20 is a lawful work rule pursuant to the Palms Hotel and Casinos case. In that case, the board found that it was lawful to have a rule, quote, prohibiting, quote, conduct which is injurious, offensive, threatening, intimidating, coercing, or interfering with other employees because the rule was not, quote, so amorphous that reasonable employees would be incapable of grasping the expectation that they comport themselves with general notions of civility and decorum in the workplace, end quote. And then he says, under the Stericycle decision, the GC has not maintained her burden of proof. I happen to agree with that. I think any human being who's not a lawyer, just a human being, can read injurious, offensive, threatening, or intimidating, coercing, or interfering and know what that means. But let's look at another rule that the judge found. We're going to go to SHOP Rule 28, which prohibited the, quote, making or publishing of malicious statements concerning any employee, the company, or its products. And here the judge said that was overly broad. Again, the GC argued that it's unlawful under what the GC called well-established precedent. Making false, vicious, profane, or malicious statements toward or concerning the Lafayette Park Hotel or any of its employees is unacceptable. And that rule in a case called Lafayette Park was found to be unlawful. And there's another case they said called American Cast Iron Pipe, where a rule that punished making false statements as opposed to maliciously false statements was ambiguous, overbroad, and therefore unacceptable. The respondent argued, look, this is just about promoting a safe workplace. Okay, here's what the judge said. I find that Shop Rule 28 is unlawfully overly broad because the General Counsel has established that Shop Rule 28 could reasonably be interpreted by employees to restrict or prohibit Section 7 activity. And then the judge quotes another case again. The board has consistently found that the rules that prohibit the making of false, vicious, or malicious statements violate Section 8A1 because they include within their prescription false statements that may nonetheless be protected. Look, I'm having a hard time figuring out the difference between, and I want to get the word right, making or publishing of malicious statements is any more vague than, what was it again? Let's get it right. Threatening, intimidating, coercing, or interfering with employees or supervision at any time. How are those two things that much different? I don't see it. You think words don't matter here, which they do. Let's look at Work Rule 21, Shop Rule 21 in this case. Shop Rule 21 prohibited the unauthorized soliciting or collecting contributions for any purpose whatsoever during working hours. Now, all of you have seen language like that before if you have a no solicitation, no distribution policy in your handbook. But you'll notice that if you've got one of ours, it's different. We use the word working time, not working hours. And the judge here found that significant because the judge said working hours can be understood by employees to mean hours that aren't working time, like breaks and meal periods. And because working hours can encompass those times, it can reasonably tend to interfere with employees' Section 7 rights, and therefore the work rule is invalid. But if you change the word working hours to working time, the phrase working hours to working time, then the rule is lawful. And the judge cites a couple of cases for that. All right? Now, the problem with this standard in my mind is just this sort of thing. How do we know what could reasonably be interpreted by an employee to interfere with the exercise of their Section 7 rights? The answer is you're not going to know until you put a rule in place and somebody complains about it and it goes to the board and the board litigates it. So, what am I asking you to do here? What am I telling you to do here? As you look at your handbooks, as you review your handbooks, as you discuss your handbooks, don't forget these standards. Give us a call. We can help you do it. But you do want to keep this in mind as you're reviewing your handbook. It's out there. We're going to have to live with it for a while. See you guys next time.